Good morning again. It's still Wednesday, January the 6th of 2021. This is a special meeting of Commissioners Court of Grimes County, Texas. It is the 6th day of January. This meeting is being held after our regular meeting that adjourned. We are at 114 West Buffington Avenue, Anderson, Texas. The meeting agenda item has been called to order. Agenda item number 2, discuss and take action on Blue Jay Solar Project. Mr. Fultz, do you want to start off and kind of update us since you gave us a new 381 to talk about?
I'll be happy to do that. First, I want to apologize for the delay in getting the proposed draft to everybody's hands. Nobody's fault but mine.
Do you mind? I know you do mind, but would you come to the podium so the world can hear you better?
Hello, is this on?
I believe it is.
So the draft was sent out yesterday or last night, yesterday evening. First is a non-attachment and then there's an attachment, as I understand it. So I think you all have that. It's not super lengthy. There's been the discussion about whether there should be 2 agreements, one for the 25-year floor, as it were, and you can call it a pilot, but the reality, as I understand it, is that the Blue Jay will pay what the valuation is, so long as it's not lower than the value of a 175 megawatt facility, which in that case, the payment would be based upon that type of facility. So it's not necessarily a pilot. You wouldn't know until the appraised value, or until the appraised value comes in, and if their facility is, let's say, 210, or it stays at a 175, and the CAD values it that way every year, then all they're doing is paying taxes based upon the valuation, not based on a payment in lieu. So there is that issue that I want to be sure we're all clear about. This is the first time that I have taken a real hard look at our guidelines and our form agreement. And I'm going to have a stern talk with the guy that drafted this stuff because...
Wasn't that you?
Yeah, that's right. That's right. There are some horrible inconsistencies between the guidelines and our form agreement. Corey tells me this may be based on, or because this was put together in kind of patchwork, that we may have drafted the agreement and then later the guidelines, but there's just really no excuse for it. And having seen those inconsistencies, I was a little frustrated when I saw those, that we didn't catch those earlier or clean those up, or that they were done originally, because there are things like in the guidelines that say there'll be an agreement and it has to contain these several things. Well, then our form agreement doesn't contain all of those things. And then there's a discussion about a 30-day notice versus, in our guidelines, it says 60-day notice about a default. In the agreement, form agreement says 30 days. Just lots of poor language, and I don't know, no sense in belaboring, I don't know where the language originally came from. I can't recall that at this time, but I will take full responsibility for it, and after this project is behind the court, I'm going to do a revamp of the 312 guidelines and application and agreement.
Very good.
And make it consistent with the 381. These guys have raised the issue, and I think it certainly has merit that there ought to be one application and one committee and one consideration for either an abatement or the 381, but give the committee the opportunity, as we have done in this case, the opportunity to consider one application and recommend the use of any of the tools that the court may have as far as economic development is concerned. So that's on my plate to get done. What I did when I received the draft from you, Judge, a couple of weeks ago, I went through and saw the notes that the Blue Jay folks had made. Essentially, they created a markup, red line version of the form agreement. And when I was looking at this with some scrutiny last couple of days, it seemed to me that I think we're better served by maybe using the guideline language rather than the form agreement, or being married to the form agreement. So the document that you have uses the guideline language when there are inconsistencies between the guidelines and the form document. I also I think, I may be mistaken, maybe the force majeure provision or some of the language I kept from their counsel. The other provisions, though, they had some in there. There was a cap on liability. It said that they will never be responsible for anything more than the grants that were provided to them or the taxes I think that they owe. In other words, there wouldn't be any damages. They wouldn't be sued for damages. I understand their request or desire to have that in there. There are a couple of other things that they made some modifications to. What I would say to you, and this is not meant to be harsh, but just be realistic, if you as a court apply for a grant through the state or the federal government, you know how many strings they put on that. You know how many things we have to do. You know how lengthy that document is, and I suspect you know how much willingness there is on the other side to make any changes, and that is just about zero willingness. So you are somewhat in that position. You have to obviously balance how much incentive you want to create for this project, but you also have to recognize that the treatment of these folks or this entity with reimbursement of taxes is not something that everybody on the street's getting. And so it's for you, you have to decide, and I think we'll probably, because the document just went out yesterday, I think there's some tinkering left, probably even from me, but I suspect there'll be input from Blue Jay and maybe you all and maybe members of the committee, et cetera. You have to decide, is this a document that you're going to negotiate, or is this a document that you're going to present? And that really is the issue. And again, I don't mean that to be harsh. You just need to decide what you want to do. And I am more than happy to accept or to receive from these guys their request for modifications to the agreement, but they're not, in my opinion, they don't have a whole lot of leverage to say to the court, we want this provision added to the document. So it's a request, and you have to decide whether or not you're going to negotiate it with their request. I'm happy to add them. I'm happy to negotiate them. I'm happy to be involved to whatever degree the court wants me to be involved. And again, I don't mean that to be ugly. I just mean I want to be sure that you recognize the position that you're in here, and this is not a typical contract negotiation. I think those are all the things that I want to say as preliminary matters. I'll shut up unless you have questions of me.
At this time, I don't. Commissioners?
I did. I think I understand you correctly, but if the paper that you sent over, the proposed agreement,
Yes, ma'am.
This is basically based upon dealing with Blue Jay. Just like this is not a.
This is not intended to be a form for future use per se, and you may see that the future form look a lot like this one, but you notice there are variances in there for the things that we've talked about. Seems to me it's probably I tell you all the time my concern about equal protection and due process, but it seems to me that a trade-off on a floor of megawatt facility is probably worthy of making some variances in this document. So I couch them as variances and or the word waiver, but those things are different than what your guidelines say, and they're different from what the form says. But that document that I sent to you is tailored specifically to this deal.
So, with that being said, when you first talked about the appraised value of the 175 megawatts, this is not really a pilot program. Is that addressed in item number F, where you talk about the 25-year, the agreement is 25 years from the date of the first grant, and will be appraised value as determined by the Grimes County Appraisal District?
Yes, ma'am, that's the exact language, and I recognize that lawyers tend to make things complicated, and at least language. The document we received from Mr. Leeper that was I think it was a previous pilot agreement that he was familiar with, is extremely lengthy, and as I thought through the things that I had heard from you all as well as from, I guess, Blue Jay, it seemed to me that the language could be reduced to that limited amount of language. Now, I would want to have the CAD tell us how comfortable they are with that language, whether that is something that will assist them in the calculation of value. You may very well hear from Blue Jay today. I assume these guys may want to tell you their side of it or how they feel about it. But I don't know if that language helps the CAD to make that calculation. So you should take input from all the sources that you have and make a decision about how to best do this. But it's going to come down to the CAD doing the valuation and Blue Jay making the payment, in theory. The way that I have written it, though, the implication, or I guess the takeaway, or one of the takeaways, is that Blue Jay is stuck with the CAD valuation. And they may very well say to you, we don't want to be stuck with that. We want the ability to protest that valuation. We've talked about that. We know that that's happening with another entity.
We had a negative opinion on annually, going to lawsuits and debating all of that. We wanted the CAD to evaluate it appropriately, and then that would be the number.
Well, and I think there's, at the heart of that, I think it's fair. I mean, if you're going to give a grant that's effectively $1 million, to say we're not going to spend hundreds of thousands of dollars contesting you over the next 25 years about valuation, that seems fair to me. Now, maybe there's some better language to get there. Maybe we can refine that. That's just my stab at it. But I'm open to the conversation. I'm open to the input of all of, obviously, you all, but anybody that wants to provide input to make this as clean and clear as possible.
So just to be clear from my understanding, this is still a 381 agreement. This is not a pilot program, right? This is not the combination that we originally talked about. This is basically, am I understanding
Well,
that?
it is the combination. So the
It's still the
381,
combination.
our guidelines and the 381 as the one time that's ever been used, as I recall, was to give a reimbursement of ad valorem that were paid. In the previous transaction, there was not a discussion of some floor about valuation for an extended period of time, certainly not 25 years. But we weren't talking about electricity generation either. We weren't talking about something that has a significant depreciable value. We weren't. So all to say, it makes sense to me that this has been offered. Mr. Leeper proposed that maybe there ought to be two agreements. In my mind, I think it's one. In fact, I think it's consideration for the waivers or the variances that you've granted, that they're willing to agree to the floor. And that ought to be, if there's consideration that holds the transaction together, in my mind, that ought to be all in one document. So all that to say, I've combined the two ideas, the 3 years of 150, 25, and the 25-year floor into one document.
To answer your question, Commissioner?
I'm trying to.
Okay.
Probably not.
So let me ask this, and it may sound foolish, but is there a reimbursement? There's not a reimbursement for 25 years. Is it?
No.
It's still the same reimbursement for the first 3 years, and then the valuation is going to be based on the megawatts. It has a floor on the valuation
Yes.
for the next 25 years. I mean, the difference.
Right, 22 years beyond the first three where the
Okay.
grants will be involved. There won't be any grants beyond the 3-year period. It'll be 22 years of this floor
Okay.
beyond the grant period.
Do we say that in this agreement?
I think so. But I mean, we can make it clear. Obviously, we need to be clear. We want everybody to have their expectations met.
I guess I would like to hear from
Okay,
Blue
anybody else have any
Jay.
questions before I sit down?
Thank you, Mr. Foltz.
Yes, sir.
I'm going to call Blue Jay out. Craig, Bob?
They do, can I,
Go ahead, please, come on up.
for the record, I'm Bob Leeper representing the committee. And I respectfully disagree with the comments about just using appraised value, even if you stipulate a 175. I'm not, the appraisal district is tasked by state law with appraising based on market value. I don't think you can put on them some artificial, where you're going to appraise it based on 175, because they're appraising for you, for the school district, for the ESD, for any taxing entity. We believe, and I believe, that a pilot is the way to go. And a pilot, as we previously stated, gives you more protection against that litigation for values because the appraisal district will follow state law, just as they have to. They will establish market value, and that's what the taxes will be paid on. The pilot will establish the minimum amount of payment to the county. School districts already got their own side deal. Will establish their own, the minimum payments to the county, and so there is no incentive for the Blue Jay, keep on calling Blue Green, Blue Jay, because that's who developed King Oak, Blue Jay, to protest the values, because let's use some hypothetical number, and we're using their values that they presented to the county, saying that these are going to be the value, our estimated values for the next 25 years. So we're setting those as minimums. So let's say that that value is $100 million. And we do a pilot that says in year whatever, you're going to pay a combination of county property taxes and pilot payment to equal what the county tax rate would be for $100 million. And let's say that the appraisal district values them at $75 million. And they say, no, that's not right, it's only $50 million. And they go to court and they litigate and they get it reduced to $50 million. They still have to make that pilot payment for that $50 million to bring it back up to $100 million. There's no incentive for them. They're not reducing any payments to the county by challenging the appraised value.
And Judge, if I could just interrupt, I was presenting the issue, I thought, as you conveyed it, and I thought it came from the committee. So I don't want anybody to think that this is my idea or my suggestion that it ought to be this way. I was following through with the email that said, here's the addition that I want to see in the agreement. So if that's my mistake, I'll certainly accept that.
Well,
I'm not here as a proponent necessarily.
Yeah, you weren't at the meeting when we talked about that, so you weren't aware of the difference in establishing a base 175 versus the values, because one of the concerns that the appraisal district representatives raised to us was in future years, them coming in and really
Appreciating it.
slashing that value.
Right.
And the committee felt very strongly, I believe it was unanimous, that this deal is predicated on the values in that chart, in that spreadsheet, that says over 25 years, Grimes County is going to give up roughly $1 million, but we're going to receive 7.1, I have the chart in front of me. And so we want to make the deal, we want to recommend to you, obviously, the deal based on those numbers. Not give them $1 million in the first 3 years and then all of a sudden the appraised value gets slashed and instead of 7 million, we get 3 million, but you've given up, $1 million right up front.
Right.
So I absolutely agree that we could write the pilot into one agreement. I'm sorry if I came across saying we had to have two. The way you have that written works great. We just need to take and put that chart in there as an exhibit to the pilot. We can take some of the language, if you want, out of the pilot that I sent y'all to look at. That's a recent pilot that was done by the Improvement District Board on which I sit. And it's the same thing. The Chambers County Improvement District #1 is a governmental entity and assesses property taxes and all of that stuff.
Can I ask a question? In the 175 megawatt number threshold, it's irrelevant, right?
Well,
If you do a
It's-
pilot and say you're gonna pay based upon your estimated value of 40 million, then why aren't we just saying the pilot's based upon that number and
But
has nothing
because
to
the-
do with megawatt generation?
well, they gave us two charts. They first came to us saying, with all the numbers based on 210 megawatts. And then in our discussion, they said, but it might be as small as 175. So what we would like to see is a pilot with a chart based on a minimum of 175. Even if they build 150, they have to pay for that. But if they build 210, we want them to
Pay on
pay the
210.
values based on the 210. And I believe we can put in there that they had to use a formula to come up with those numbers. We need to plug that formula in of megawatts times whatever their multiplier is for each of those years to come up with a number. And if they build a 195, then the pilot value is more than the 175. I want Grimes County to get every cent that they are entitled to based on the size of the project. But 175 needs to be the floor. I mean,
Right.
that needs to.
And that's what we said, because that was a heavy part of our discussion, that if this starts getting devalued and below the 175, we don't want them to being assessing on $1,000. We want it based on the value of that 175 megawatt.
Because the decision the committee made and their recommendation was based on those revenues for the county.
That's correct.
Okay, but you want Blue Jay to agree on a formula that arrives at a minimum value versus 175 being the trigger that we're talking about. We're asking them to agree to a minimum value. It's based upon their estimated values.
Well, you can't, they can't agree to a minimum appraised value because.
No, I mean to calculate the
To
numbers.
calculate it, yes, sir.
That's all.
Yes.
Okay, okay. But,
Yeah.
and I was thinking that you were saying we want to have the 175 be the calculation of the CAD. What we're saying is something entirely different from that.
Well, it was the 175 was the smallest facility.
Yeah, I
to
understand,
allow.
but it's
then the-
for use of
but the,
calculation.
Yeah, but the breakdown of the price would be based on the actual megawatt of the facility. And then, like you said, each chart would be different based on that
Sure.
formula.
And I would imagine that we could work with Blue Jay and get the base. I didn't create those spreadsheets, so I don't know what the formulas were. Come up with that formula.
So it's 800,000 per megawatt times the 175, and in the first 3 years, they times it by the 78 because they took in the tax credit into consideration. And that's how they're coming up with their estimated values for the first 3 years. And those estimated values for the first 3 years are consistent because it stays that same value apparently for
That
3
was
years
what the
before.
Capital Appraisal Group, the firm that does the appraisals
Right.
for,
Yes.
is what they gave us,
And,
essentially.
and I'm confident that between Jesse and Blue Jay and the county attorney, we can come up with a cleaner formula to put in there and say the minimum multiplier for the megawatts is 175. It shall be the actual megawatts used in this formula, but the minimum is 175.
Right.
Yeah.
I just couldn't send that to you because I didn't, all I could do was make the chart using their formula.
Well, in summary, that's what the committee finalized on, that we were going to have a minimum floor, and the minimum was 175. If I didn't communicate that properly.
Yeah, the 175 is for purposes of calculation,
Right.
that we do
Yeah.
to determine the payment that they make.
Right.
As opposed to saying that's how the valuation is achieved by the CAD.
Right.
Right, totally different.
But, you know, the question that was raised earlier, the concern that was raised earlier about litigation values on appraisal and stuff like that, we talked about that a lot at the committee.
Yep.
And establishing the pilot pretty
Eliminates
much
that.
takes that off the table. They can still do it, but there's no incentive to do it, because no matter how low they make it, it doesn't affect the school district, because theirs is set. It affects the ESD, whose tax rate is that, because they've got to make the county whole on the pilot for anything below that value anyway.
Right.
So just to confirm, the backstop is 175 megawatts times whatever. So if they build 250 megawatts, they're gonna be up here and 175 is down here.
No, they're going to pay on the 250, whatever they
Well, they're
build.
gonna pay on the 250 because
Right.
they're gonna get taxes, but I mean, their threshold of where they have to pay back
The
is.
pilot value will also be 250.
Okay.
Yeah.
So we're gonna take the formula where in the 175 chart and the 210 chart, you showed our revenue. And instead of putting the charts in there, we're gonna put the formula in there. So if you build 250, the pilot number goes up. If you build 175, that's the lowest that the pilot number could be.
Right.
And is the CAD looking for, are we talking about a pilot that's the difference between this number and what they
the
pay in
CAD.
taxes?
Yeah, the
We're not
CAD,
asking the CAD to do anything.
the CAD is really not involved in this at all, and that's one of the things that they said was they can't be, because state law says they have to just assess market value,
Right.
appraised value. And so, very similar to the pilot agreement that the ESD has with Garland Power and Light, for that power line. Yeah, they don't have to pay us taxes, the appraisal district's not involved, other than they send us what the appraised value is each year, and then we send them an invoice based on our pilot of our tax rate times that.
But they're paying the higher of the two, right? So if their taxes are higher than the pilot, then they're paying the taxes.
Absolutely. But the pilot is a make-whole agreement for the county that
If
says
it
they
gets
will not.
below that estimated, depending on the megawatt, there's an estimated depreciation of value, and based on that estimated depreciation of value, that's the floor.
That's the floor.
That's what we want, it to be
Right.
the floor, yes. Depending on the megawatt. So, it's not necessarily just, we want the minimum facility going in to be 175,
Right.
but we want, based on, taxes, we don't want to have to come in and the appraised value went below that minimum that we've seen in the chart, the estimated taxes. We don't want to have to fight to get that estimated tax or have the
And
appraisal
and
district fight.
actually, Commissioner, with this agreement, we don't care what size they build.
Yeah.
We're not telling them they have to build 175.
No, that's just
We're
the-
telling them they're gonna make a tax plus pilot payment equivalent to 175. I think they're gonna build 175 or bigger, but you have to have a floor someplace. But the agreement will not stipulate they must build 175
Yeah.
megawatt. Maybe it comes in, they build
Minimum.
173 or whatever, but for purposes of payment to the county, it's
175.
based on at least 175.
Bob, thank you. Any other questions for Bob at this time? Okay, Bob, if you'll stand by. Craig, I think you have some comments to make, but you also want to update the court on, I guess, a bit of a business change from
Yeah,
y'all's
I'm clear
perspective.
on the solar project, and we can get to that in a minute.
Okay.
I think while we're on the agreement, I want to say first, thanks to John for getting us the draft. I know that people had to work over the holidays, and we haven't had a chance to fully digest it, but in taking a look at it, I think it's a framework that we can work with. I'm having a hard time a little bit understanding where exactly, what direction you're wanting to go, because I fully appreciate it. In most counties we work in, they want some assurance of, what the county's gonna be getting in the way of revenue. And usually that takes the form of a minimum megawatt size for tax purposes or a minimum dollar investment amount. I haven't seen one that tries to get into the details of the way the appraisal districts work and the appraisal, the schedule that's in our application is our best guess at what the values will be, but that's a negotiated process with the appraisal district. And so I guess the agreement that you sent us, I think, is a framework that we can work with. And so we'd be happy to redline that, but if that's not what you're talking about, well, then I think we would need to see that, because this is a framework we can work with, that at a high level, I'm sorry.
So I think the concern with the committee was the fact that there's the appraisal district sets a price, and you didn't agree with the price and want to decrease the appraised value, and it would be below what your estimated taxes were each year. Like say year 10, you come in and say no, the appraisal district sets a rate, and you say you wanted it below that rate, but even below the estimated taxes for that year. I think we want to make sure that you at least pay the estimated taxes in that chart, depending on the megawatt. So if you came in with a 210 megawatt, the chart that you gave us for year 10, you said the valuation would be this, and we wanted that would at least be the minimum valuation.
So regardless of what value the appraisal district comes up
Yes.
with, you're saying? And I don't actually know legally how that works, to what degree, the commissioners court or we can, so I think there's a process that's established for doing that. And, the 175 megawatt minimum, I think that makes sense, and I think that is something we can do. If you're talking about putting, the schedule, for example, that's in the application and saying that the appraised value will be, this or something higher, then I think we'd have to take a look and see what the language says. Because then, if we're talking about 3 years of grants, you know, with a 25-year commitment on values that we're trying to estimate, but that we don't know what are going to be, you know, 5 years, 10 years, certainly not 25 years, that's a more difficult thing, and I think we need to have lawyers look at it. You know, we got this last night and took a look at it, and it looks like a framework, and our lawyers are still reviewing it. I think we're all still digesting it. But if you're talking about significantly changing that, I think we'll need to see what it looks like, because that's not a process I've seen or a structure I've seen.
And just to be clear, I was not party to this entire conversation about the things that Mr. Leeper presented, so.
That's because you had court that day and had to leave.
Yeah, I'm just saying that
Okay.
the draft, that paragraph F, is not what Mr. Leeper was talking about. And so I need to revamp that. I was not aware of the intention of the committee, so I will fix that, and I will make it as clean and clear as I possibly can.
Well, because we don't want to pay legal fees in the future, like we've had to do with other companies, to where, okay, they don't agree with the appraised value and want to drop it. You know, versus the fight of what the appraised value, say it was $120 million, and you said, no, it's $100 million, and that happened to be what the estimated rate was on the chart for that year, then, you know, we would rather settle for 100 than have to fight it legally. You know, we don't want to spend money in court,
Okay.
you know, contesting the values.
So you're
Appraised
basically
value.
trying to circumvent the process with the appraisal district to say this is what the value is gonna be for the purposes of this agreement and the county.
Yeah, yes. Well, I mean, we, like I said, we don't want, and not to say that you would come back and say, and protest any appraisals and say, no, we don't want to pay that, it's a lot less than that.
Yeah.
You know, that we've had to go into, spend money.
We don't want to spend the tax money we would have received in legal fees, and at the end of the day, we win, but we lose.
Yeah.
Got it, and I appreciate that point. I guess, you know, keep in mind that we're not the only ones that are part of these formulas and these decisions.
Sure.
You know, you have an appraisal district, your appraisal district has a third-party consultant that specializes in these facilities, and there's also, you know, one of the variables in that equation is set by Congress that we don't have any control over. And so, you know, we're doing our best to estimate those, but if you're talking about getting ahead of all that, then we'd have to take a look at it, because that's not something I'm familiar with or seen before. And I appreciate the agreement that Bob sent. I don't know that pilot is the right term, and that agreement is really analogous, because that's a county that's issuing bonds for that facility. And when you're issuing bonds, of course, you need a much harder, you know, understanding of what the revenue coming in to pay for those bonds are. Well, we're not talking about that here. You know, the county's not incurring any costs, the county's not issuing any bonds. You know, we are hoping to make a very large $200 million on the order of investment in the county, and appreciate your considering, you know, reducing that a little bit through a grant. And we had originally offered a pilot agreement that is normally done under a 312 agreement, because it is in lieu of taxes. So if you're not paying taxes, it's an abatement, and then it's under the chapter 312. But, and I think we changed directions to the 381, and even though it's substantially lower than what we had originally talked about, I think we're trying to make it work. But we would just need to see this, if you're talking about doing it a different way, and I think I understand what you're saying, I just want to make sure everybody is aware there's a number of other, you know, pieces of the puzzle that we have to be mindful of. We have to get the project financed, and, you know, that means a lot of people have to look at it and see that it passes muster. So, I don't know, Stephen, if you have anything to add to that.
No, I think we're still kind of needing to put everything still on the table. And, you know, another iteration of the 381 would be good, and kind of just get the full document of what all everybody's wanting to sign up for.
Which I guess leads me to one of my questions here is the process. You know, John sent us a draft, and we're digesting that. I think we can pretty quickly turn around a red line of that. Do we send it back to him? And I think John asked this question, is he negotiating this agreement on behalf of the court, or will it be the judge, or do we need to reconvene the committee? Because as we've talked about, you know, this, you know, we would very much like to keep the process moving.
For the process, I would suggest if y'all have changes and modifications, that you send that to John. John would review that, and he's very good about giving the court, because it's not going to be my decision, it's going to be our decision. But we would like John, and I hope I'm speaking correctly for the court, but like him to review it first and make us, because he's very good at making us aware of, hey, you need to think about this, or what are your thoughts on that, or you need to consider this point. And
And
he,
if I could ask if you'll just hold off now that now I know what the deal is. Let me revise it and send it back out. And if you'll give me till Friday, I'll get it in front of you. But I want to be sure that we're making the best effort to capture what the committee has recommended to us.
Okay. Yeah.
does that work for you guys?
Yeah, then we'll do that,
Okay.
we'll take a look at it, and what we'll do is we'll quickly send a red line back, because without seeing it, it's hard for me to know whether, what changes we would need to make for it to be workable for the project.
Okay.
And I just remembered I have CPS docket all day Friday, so you may have to give me till Monday.
Okay, well, appreciate it, the sooner the better.
Or you can work Saturday and knock it out, John.
You bet.
Okay.
Put that down. You guys stay up at your email machine on Saturday.
I'll be there.
Get your email.
So just Saturday and make us work on Sunday.
That's right.
After lunch, so go to church.
Okay, then then I think that's where we are on
Okay.
the agreement. I also wanted to let you know about a change in the project. I let the judge know yesterday. As a developer, part of the process for us and seeing a project through is bringing on the long-term owner of the project, and that just happened over the holidays, so I wanted to let you know about that. And I'm going to introduce Robert here in a second. Robert Pena is with a company called Enel Green Power, and they're a great, very experienced player in the energy space in the country, and we've worked with them on a number of projects. And so as of over the holidays, the solar project is now technically owned by Enel Green Power, and we will be working with them, so we will still be involved. Nothing changes in terms of the court, in terms of this agreement. They've acquired the project from us under the assumption that this agreement gets done, because it's critical just for them, just as it is for us, for the project to happen. And Steve and I will still be your main points of contact. My company, Open Road, will still be involved, but I want to introduce Robert, because they are now the new owner, and we will be working with them moving forward, and we're very excited. So I want to introduce Robert.
Did you sign the paper on the agreement before you were in court today? Because we really are nice people to work with.
Good morning, Judge.
Good morning.
I couldn't get my pen to work. I
Okay.
apologize. Good morning, Commissioners, and good morning, everyone. Again, my name is Robert Pena, and I am the project developer for Enel Green Power. That is, for
Could
the
you
record.
could you
that's
spell
spelled
that?
E-N-E-L. E-N-E-L, Green Power.
Okay.
Enel Green Power is headquartered out of Andover, Massachusetts, and has their offices throughout the country in Pennsylvania, in Kansas, Chicago, and hopefully soon here in Texas. I myself am based out of here in Texas, originally from the Rio Grande Valley. I've been in the renewable energy business, both wind and solar, for the past 20 years, working in many, many different counties. In fact, my colleague and I were joking on the way up, saying 2 years ago we could have bitten our tongue when we said we'd never done work in East Texas, and here we find ourselves. So it's a pleasure to be here, and to kind of tell you a little bit about Enel as a company. They are a large international owner and developer of power facilities. Enel Green Power is presently developing, our development group is presently developing along the East Coast, central United States, from Chicago through the Midwest, Kansas, Oklahoma, Nebraska, Iowa, and presently in Virginia, New York markets, and is prepared to continue making a big step forward into the state of Texas. Currently in Texas, we have a couple of projects owned and under operation just west of Fort Worth, and we are presently developing a portfolio of 12-plus projects here in the state as well. So,
Are your projects wind or solar?
a few wind, a handful of wind projects, mostly solar,
Okay.
or at least under my hat, it's 100% solar. And so Enel was able to have been introduced to Open Road, and we appreciate that introduction with Craig. And now we will be connected at the hip, partnered and working closely together to bring this project to fruition. We will be updating our application for the record so that the ownership is reflected under Enel, and also updating company information to you. And the other interest or other item that we'd like to continue addressing with you is our commitment to also have a road maintenance agreement in place very soon. So we're committed to that. Craig has briefed us on that, and we're very prepared to move forward to ensure that your county roads are maintained and kept in operable working order. So, aside from that, I'll leave my business card for the record with whomever you'd like, with you, Judge, and pass that on to the rest of the commission. And as far as I hear now, Craig and I will be here together going forward.
Awesome.
Okay.
Very good.
Thank you.
Good to meet you, and thank you.
Likewise.
Are y'all gonna maintain the project under Blue Jay?
That is correct, yes, sir. We have acquired Blue Jay Solar LLC.
All right.
Yes, sir.
Very good. Thank you. Commissioners, any comments or questions for anybody? We've got the audience here. I know it's a lot, and we've had some discussion, but, so just to be clear, John C., Mr. Foltz, you're going to work on revising what you've submitted thus far, and you're gonna try to get it to them no later than Monday.
Correct.
And you have a fairly clear understanding of what we're asking for from, as a court? And my apologize if I didn't do a good job of that to begin with, and I probably
No,
did.
it's okay. It makes no difference. We'll get right. I like the idea that Jesse has the formula down to what it is per kilowatt hour. You may see that in the draft that I come up with, but I think that, I'm gonna draft that, and I'm gonna circulate it in all likelihood to all of you, as well as to Mr. Leeper and
Please.
Jessica, before we send it over to the other side. And if there's something that lacks clarity or something that anybody disagrees with, is that being the recommendation of the committee, then certainly contact me. Obviously, don't reply to all and don't talk to one another about it, but I should have that draft to you. It would be Friday. These Zoom dockets take all day long. It's silly, but my hope would be to have it in y'all's hands tomorrow.
Yep, wonderful. Bob, I want to thank you for all of your input and your previous expertise in helping us and, helping speak for the committee. So, Commissioner Mallett, anything from your standpoint or from the committee's standpoint as you're a sitting member on that?
No, I think we.
We're pretty well
touched on
covered.
that.
Mr. Pena, welcome on board.
Thank you.
Craig, Stephen, thank you.
Thank you.
Sheree, thanks for getting the special meeting together.
Yes, thank you.
With that, if there are no further comments, we'll go to agenda item number 3. Is there a motion to adjourn?
I make the motion we adjourn.
Second. Commissioner Mount, was that you? There's a motion before the court on agenda item number 3 by Commissioner Walker, second by Commissioner Dobianski. Is there further discussion? And hearing none, all in favor say aye. Aye. Opposed? We're adjourned.